Accused number 5 does also not, who is also incarcerated at Khosi Mampuru, does not have pads on the on his leg irons, and they say this decision was informed by an earlier escape by an inmate from Bavianspoort prison, and a decision was then taken that prisoners will no longer be allowed to put the pads around their ankles, because apparently what happened in that instance is that the prisoner removed the pad, then subsequently removed the leg irons. And we are told that they had to physically carry the accused to take him to, this now accused number 3, physically lift him up to the vehicle, and yeah, that's how he happens to be here, my lord.
Okay, fine. Where's Mr. Matlala then? Yeah. Are you? Yeah, you don't have to take the oath. What is the latest instruction about prisoners, so-called, not being allowed to have a sponge underneath their cuffs?
My lord, the instruction was from the area commissioner,
All right.
Mr. Kosa,
Okay.
which we received on the 12th of July,
Right.
2025. And the instruction was based on the escape that took place at Bavianspoort,
Okay.
where the offender had the sponge and the cuffs on top. The offender took out the sponge, and the cuffs could easily get out of the leg, and the offender hit the official with those cuffs, and he escaped. Up until today, he was never found. So we only got instruction from our area commissioner as Khosi Mampuru that we should not allow offenders to put in those sponges when they come to court.
So did you explain to your inmates at Khosi Mampuru?
Yes, I did explain to offender Ngube at the center. I think it was last week, if not last week, to say this is the instructions, and just take note that when you go to court on the 21st, we won't allow you to put the sponges when you go to court. Yes, and the response from him was that if he's not going to be allowed to put the sponge on his leg, he won't go to court. That is what he told me.
And the other inmates, did they also adopt the same attitude?
I'm only having Ngube from my center.
I see, okay.
Yes, I only addressed him. The other offenders, I don't know.
Okay.
Yes, Your Honor.
So when is this diktat, when is it going to end, if at all?
I don't
You don't
know.
know?
I don't know. Your Honor.
So it's official. It's not like you're punishing anybody.
No, we are not.
Okay, thanks for the explanation. Thanks.
Thank you.
Yes, Mr. Baloi, let's go on.
As the court please, my lord.
My lord, are we not allowed to respond?
I don't know why don't you respond, because I was asking the gentleman whether it's official. He says it's official.
It does not end up there, my lord.
Hello?
It could be official. I'm saying it does not end up there. It could be official, but we've got the right
Okay,
on behalf
okay,
of
let's
the
hear you. What
accused
do you want to
person
say?
respond.
Yes? Yes, let's say.
My lord, I've got instructions.
Yeah.
That accused number 3 is in pains.
He's what?
He is in pains. Yes. He is unable to concentrate. I'm unable to receive any instructions from him. If the court were to insist that despite this gross violation of a human right that he's been subjected to, that this court says he can continue, I wish to inform the court, my lord, and with due respect, that I do not want to be seen to be part of that violation of a human rights, of the right of Mr. Mnube when attending this trial, because he is not only being foot-cuffed, he's also being handcuffed. Mr. Matlala does not address the issue of him being in handcuffs when his colleagues or when the other accused persons are not cuffed on their hands. The state does not address that too. But as I'm saying, my lord, on account of the fact that Mr. Mnube is saying he's feeling pains that affect his ability to concentrate in the trial, and I'm also unable to get instructions from him because of this inhumanity that he's been subjected to, I am not willing to validate what he is going through by simply standing up here and pretend as if nothing is happening. Mr. Mnube is all right with him. If this court were to say that this trial should proceed despite the complaints that he's raising, then I am going to request that I be excused from representing Mr. Mnube when he is in the condition in which he is. I'll only proceed to represent Mr. Sibia up until such time that Mr. Mnube gets somebody who will represent him on the condition that he is facing now. In other words,
which condition is that? He's in pains.
He is in pain, my lord.
Yeah, what is wrong with him?
What is wrong with him, my lord?
Yes, what's wrong with him?
He says the leg chains without those sponge things are
No,
injuring
let's
him.
address the question of pains. You say he's in pains. What pains him?
But I'm addressing that, my lord.
Oh, I see.
Yes.
So
He is saying those things, those leg irons are injuring his leg, his ankle. That's the pain that he's going through.
I see.
Yes. And I am saying,
Let me just understand. Since 19, is it when this trial starts before Mauma?
February of 2022, man.
February 2022.
Yes.
Was he always having the cuffs, Mr. Baloi, since February 2022?
Well, I assume so, my lord, in light of the fact that the decision to not have pets underneath the foot cuffs was informed by this escape at Bavian Sport. So I suppose, as Mr. Matala mentioned, this applied from the 12th of July 2025.
Yeah.
this is what Mr. Mnube is saying, my lord, that ever since he started to attend this trial, he has been always having those sponges that serve as a cushion from the leg irons. So it comes as a surprise for him now that he should be told that he's no longer supposed to be wearing these things simply because somebody had escaped at Bavian Sport. What does the escape of Bavian Sport has got to do with him? Even if that's a national legislation or it's an official statement, my lord, but it is unconstitutional. The constitutionality of which must then be tested. And if the court again were to insist that he should proceed the manner in which or in the condition in which he is here, I am not prepared to validate that, my lord. Otherwise, I'm going to request that we adjourn, we bring an agent application for that unconstitutionality of that directive to be tested. Thank you.
Yeah, when do you intend bringing it so that I can postpone? When do you intend bringing it?
I don't know. It might take me 3 months. I don't know.
Fine.
Yes.
Doesn't matter.
Yes.
Give me a date so that you postpone.
I don't know. I don't have a date, my lord. It will depend on the court's
I thought
attitude.
you said you wanted to test the constitutionality.
I am
otherwise.
saying if the court were to give a directive that this trial should proceed despite the consents or despite his consents of this unconstitutionality, then I'm going to request that this trial be postponed. It will depend on what the court will rule after this argument.
Mr. Gadoi?
I also wanted to make some solutions. Let me address the court perhaps on what Mr. Matlala misses to tell this court, my lord. And I'm only going to deal with the use of mechanical restraints in terms of the Correctional Services Act 111 of 1998. And that is governed by Section 31 of the Act and Regulation 19 promulgated in terms of the Act. And it reads as follows, Section 31, my lord, subsection 1. If it's necessary for the safety of an inmate or any other person or the prevention of the damage to any property, or if a reasonable suspicion exists that an inmate may escape, or if it is requested by a court, a correctional official may restrain an inmate by mechanical restraints as prescribed by the regulation. And then Section 31, sub 3A. When an inmate is in segregation and mechanical restraints are to be used, such use of mechanical restraints must be authorized by the head of the correctional center, and the period may not, subject to the provisions of paragraph B and C, exceed 7 days. That is what the court asked. Mechanical restraints may only be used for a minimum period necessary, and this period may not, subject to the provisions of paragraph C, exceed 7 days. Paragraph 3C, 31.3C, my lord. The National Commissioner may extend such a period for a maximum period not exceeding 30 days after consideration of a report by a correctional medical practitioner or psychologist. Paragraph 31.3D. All cases of the use of mechanical restraints may be reported immediately by the head of National Center to the National Commissioner and to the inspecting judge. And then 33.5, an inmate who is subject to restraints may appeal against the decision to the inspecting judge who must decide thereon within 72 hours after receipt of the complaint. Paragraph 31.6, mechanical restraints may never be used as a form of punishment or disciplinary measure. And paragraph 31.7, mechanical restraints, in addition to handcuffs or leg irons, may only be used on inmates when outside their cells. Now, my lord, we see a discrimination happening where some accused from the same center have got those protections and Mr. Mnube does not have. And the reasons that are given, my lord, I'll submit, is very flimsy. You are saying somebody escapes in Bavianspoort, therefore let's punish Mr. Mnube for that. Because for me, that's a sort of punishment. No rational reason is given except to say there was an escape in Bavianspoort, my lord. I'll leave it at that, my lord. But I wanted to point that the period is not indefinite, my lord, for the removal of the protections, even the leg irons themselves. And there are certain areas where leg irons are not even allowed, my lord. As the court pleases.
Yes, sir.
My lord, in respect of accused number 5, Mr. Ntuli, he's also kept in Kgosi Mampuru, my lord.
It's on, kept what?
In Kgosi Mampuru.
Yeah, okay.
Yes, yes, my lord. He also has the same complaint, my lord, that he has been attending this case since 2022, when we started this matter, my lord. And at all times when he was attending court, these pets have always been put on him in order to prevent the injuries that are caused by the leg irons, my lord, to the ankles. And it is only today, this morning, when he was told that he is not allowed to use pets anymore, which he has been using since the inception of this matter. He has never been informed of any reasons behind the decision that has been taken by the area commissioner. The reason, which has been explained to this court by Mr. Matlala, my lord, has never been communicated to Mr. Ntuli. Above that, my lord, I submit that even if it's the reason that Mr. Ntuli should be punished or penalized for someone who escaped from another prison, my lord, that communication I have requested as the legal representative of accused number 5. I've requested that communication for the area commissioner from Mr. Matlala to say, give us the communication, whether it's an internal memorandum, whether it's an email, the instruction that has been given, so that we can be able to apply our mind and take the instruction, because someone's right is affected by such decision by the area commissioner, which is the constitutional right of the accused before this court, my lord. My lord, accused number 5 says he is also affected by this decision to such an extent that he can't concentrate, my lord, on the proceedings because of the pain that is caused by the leg irons when he's moving. The distance that he's moving from the cell to the car and from the car inside this court premises going upstairs to this court, my lord, which also makes more impact on him. My lord, the decision, the accused number 5 is affected by such a decision, and therefore we ask, my lord, that a directive be given to the correctional to continue in supplying the protective pads that have always been provided for the past 3 years, my lord, in order to protect such inhuman or such injuries that are occurring to the legs. My lord, also, if there is someone, if we're to apply our mind to the decision that has been submitted before this court, it means if there is someone who is escaping from another prison, then other prisoners from other center will have to be punished or will have to be penalized. That decision, my lord, or such occurrence is irrational, it's unlawful, because it has no basis. There is no profound or proper reasons placed by the area commissioner as to why these accused should be affected by such an escape, my lord. And we have not been informed as to how many, if we have not been informed if there are any other measures that can be put in place in order to ensure that the escape does not happen, other than the decision that has just been taken by the area commissioner. Therefore, we submit, my lord, that the decision by the area commissioner is unlawful, is wrong, and inhuman, and it is unacceptable. Lastly, my lord, the manner in which the accused number 3 has been brought before this court undermines the justice system of this country. He cannot be dragged by the group of warders, dragged up to this court in such a manner, my lord, as we have been told that he has been dragged out from the cell because pads have not been provided for. So the substitute that has been put is to get these big men to come and lift him up and bring him in court. It is inhuman to us. It is affecting us also as well when we see such occurrence happening inside in court, my lord. Therefore, it is my submission, my lord, that the decision that has been taken by the area commissioner, my lord, is unlawful, is irrational, and is wrong. It cannot be affected. It cannot be accepted, especially in this case, my lord, that is affecting the client's concentration in order to concentrate during the trial, my lord. I submit, my lord, that the accused number 5 also is unable to proceed with the trial because he's affected by such occurrence. Those are my submissions, my lord. Thank you.
Yes, Mr. Mamalo?
No, I have nothing further to add.
No, consult your client.
My lord,
Go and consult your client also.
I must approach him.
Yeah, I want to hear
Oh, all right.
what he says through you.
I'm instructed, my lord, that he's got the pads on. He's got the pads on, so he's got nothing to add on what has been said, except to say that he was upset this morning because his co-accused, accused number 3, was pulled, I think, from the cells downstairs to court, and he then informed him that it is going to be the manner in which this process is going to be ongoing. In each and every time that he's going to be brought to court, he's going to be pulled from the cells to court. And again, my lord, if you can look around this courtroom, there is more than 15 members of the Sergeant Police Services combined with members of the Correctional Services. So this issue of escape, it doesn't take the matter any further. There are so many members of the Correctional Services here. How can one escape in the presence of so many members of the Correctional Services? More than 15 members who are present in this court. Accused number 3 has been wearing these pads for the past 3 years. For the past 3 years. Not only in this court, when he first appeared at the Bosbeck Magistrates Court when they were making their first appearance in this case, he has been wearing these pads for so long. Why today, the 21st of July, 2025, is then prevented from wearing these pads? It's gross violation of his rights in terms of Section 35 of the Constitution. So I think the court has to intervene for the sake of progress in this matter, to allow the accused to continue wearing these protective pads for the sake of seeing progress in this case. That is all, my lord. Thank you.
Yes, Mr. Baloyi.
As a quick please, my lord, our submission is that the Section 31 that Mr. Ramasepli referred to, that deals with the use of mechanical restraint, is not applicable here. It's not about mechanical restraint. It's about the use of the patches or the sponges. My lord, we are told, and we've just confirmed this with Mr. Matlala, that the use of sponges, it's not ordained by correctional services. It's something that inmates themselves make. So once again, my lord, it will boil down to, is it a right, is it a privilege? And I think perhaps it's a matter that should be decided on affidavit, keeping in mind the discretion that an area commissioner has on such matters. I don't know whether it's something that we can just resolve here, my lord. There has to be a formal application, and the matter then properly ventilated as to the use of these pads, which, as we've mentioned, my lord, are made by the prisoners themselves and not provided for in the Correctional Services Act.
Sorry, the the application to the complaint we lodged to the judge in charge of those issues. It's a section.
Inspecting Judge of the Presidency.
Yeah, inspecting judge. It's a section.
Is it the one dealing with the inspecting judge? Or-
Yeah, the inspecting judge. Apparently, you can lodge a complaint.
Yes, yes, yeah. We just have to quickly verify that. My Lord, what I could quickly find out is that in terms of section 111 of the Correctional Services Act of 1998, it empowers the Judicial Inspectorate for Correctional Services to inspect and report on conditions of detention and the treatment of inmates at correctional facilities, conduct investigations, and handle inmate complaints. So it appears that if the inspectorate, the Judicial Inspectorate for Correctional Services has to be involved, they must be informed, and then they will then have to come and make an investigation.
Where is his offices? That camera, is it?
It's obviously the head, my Lord, is Justice Edwin Cameron,
Yeah.
the inspecting judge. I would imagine, my Lord, that he should be based in Cape Town. It's something, my Lord, that we need to verify. But maybe Mr. Masala can just quickly help us in this regard.
Yeah, where's Mr. Matala?
as
Who's the head of the prison? It's
It's Mr. Koza,
Koza.
the area
Is
commissioner.
that Koza? Where is he? Is he in his... He is present today.
Yes, but he's taking a consultation today.
Ah. And you say he issued this order?
Yes.
Yeah. Okay, thanks. Yeah, I'm going to suggest all the accused must lodge a complaint with Judge Cameron. You'll see how you fashion it through your representatives, your legal representatives. In terms of, as you say, Section 11, is it?
111.
111, yeah, 111. Subsection?
My colleague says it's section 93, my Lord.
93.
Yes, 93. And I see that there is an office here in Centurion of the Judicial Inspectorate for Correctional Services.
Yeah, fine. But it is addressed to the judge himself, is that not so?
Yes, yes.
Okay, fine. I suggest that should be done because Mr. Koza will come and tell me that people escaped and this is his order. So we must go to the highest authority in the country, Judge Cameron. Mr. Mnisi, what do you suggest? I think I'll make an order now that your client should lodge a complaint and address it to Judge Cameron, okay, about what you told this court.
That is proper, my lord.
Yeah.
But in the meantime, I'll still be struggling to get instructions. from
Yeah,
you.
in the meantime, we adjourn.
Thank you, my lord.
If it happens when Mandela is resuscitated, fine.
Yes, thank you, my lord.
Mr. Ramsipi, the same applies to you, okay? Mr. Mumalo, the same applies, okay? Ms. Shalol. So you'll all lodge complaints to the judge.
Sorry, my lord, I'll be lodging a complaint on behalf of accused number 3.
You don't?
I'll be lodging a complaint on behalf of accused number 3.
Yeah, your client.
I represent accused number 4. He is not affected.
Oh, he's on bail.
No, he's not on bail. I mean in terms of this issue, the issue that at hand, that you are discussing now.
Oh, it doesn't affect him.
No,
He's happy with having,
he's got the sponge on.
yeah,
Yes,
so he doesn't have a problem.
he doesn't have a problem.
Number 4, that is.
Yes.
Okay.
Well,
Yeah.
Maybe before we adjourn, can we just make it this practical suggestion that we maybe adjourn until 2? Let's see if we cannot engage the area commissioner and Mr. Matlala to see if perhaps we cannot find a middle course. I think adjourning the proceedings, my lord, there's already a